So now that I've very gently eased you back into the auditorium, we're going to move into, thank you, Dan. We're going to move into the Q&A. Just as yesterday, we have two mics that we'll ask people to line up for. Because we are recording this, we want to make sure we're able to capture your thoughts as well. And again, we have four panelists, and let's go. Betsy, why don't you start?
Okay, can you hear? Okay, so being that I'm from the law school, I'm Betsy Bartholet, I'm at Harvard Law School, I'm, of course, particularly interested in this law panel, and I thought part of what was interesting was, and it was really illustrated by the first two talks, by Wendy and Lisa's talks, was how variable the law can be. So it is capable of focusing on the anonymous statistical group, and I think the degree to which it does really has almost entirely to do with level of sympathy with the substantive rights. So I did want to comment some on Glenn's presentation because although I agreed with everything you said, Glenn, I also thought it made it sound a little as if the judicial process always operates the way you described, whereas I think instead it's enormously variable. So one area in which I teach employment discrimination is one where for a period of time in the 60s with civil rights law, employment discrimination in particular, there was enormous sympathy by the Supreme Court with the idea of the importance of changing, upending the segregated world, if you will. And there was enormous sympathy during that period to both class actions and to group theory, disparate impact theory, which in brief says if there's a statistical impact, the presumption is the employer's policy is unlawful and very heavy burden to justify. And in terms of class action in those early days, it was enormously, every civil rights case was declared a class action, no problem if you asked. Very broad classes and were allowed, including all sorts of unidentified people, and victories under group theory and class action theory really were on behalf of very large groups, and policies were declared unlawful for, employers had to change their hiring policies in very dramatic ways that helped all future classes. So I think the Walmart case that Glenn mentioned, basically the court has at this stage made it near impossible to bring a class action for anything other than the kind of overt discriminatory policy which no longer exists. Very handy because the court is, seriously dislikes civil rights law. So I just think it's important to realize that our system is enormously responsive to those underlying merits as perceived by the court.
I think that's absolutely right. And again, in theory, all these procedural rules and devices are what we call trans-substantive. They ought to apply across substantive areas. But as Professor Bartholet correctly points out, in reality, we're all legal realists now. In reality, the interpretation of the way in which the court, it finds exceptions when it wants to, it bends rules when it wants to, and then it adds new roadblocks when it doesn't. Something that came out of a colloquy, just a conversation we were having that's worth emphasizing as well, in the sense that just as yesterday we were told that being shown the starving child, there's a lot more, even when you add the statistics in, it turns out that makes people less responsive than if you had just the photo of the child. That in a sense, we're always, as lawyers, we're storytellers, and we're always choosing poster children for our causes, right? And that's sort of interesting in that even which cases get brought and which poster children get brought, there are clear distributive effects here. But yeah, I definitely don't want to leave you with the impression that the Supreme Court is just these standing rules that are uniformly put no matter how sympathetic or unsympathetic the defendant.
Okay.
Yeah.
Yeah, I think that's a really important point, and if this isn't on, I can just talk louder.
No, I think we can hear you.
Yeah, okay. One thing that I was struck by in your presentation, Glenn, is the focus on standing and as if it were a doctrine of identified life. And to me, it's really one of these most variable and manipulable of doctrines. So for example, in the environmental cases you mentioned, it strikes me, those lives are absolutely identified. The people who brought those cases are identified. The question is whether they had the kind of interest the court counts in determining whether they have standing. So I, for example, I use these kinds of examples with my class all the time. I care deeply about the polar bear. I'll never see one. I'll never visit one. I do care. I'm hurt today in this room if they go by the boards. I'm identified. It's just I don't have an interest that counts for purposes of the Supreme Court, even though Congress has embodied that interest in law. So it is interesting. I think your framing was very interesting. It's just that I would have a take on it that would be much more according to whether the court thinks that the injury matters, rather than whether the person is identified.
Great.
This question is to Matt Adler. Can you, maybe I missed it, but can you please define, how do you define the identified lives in your analysis? The reason why I'm asking is that, and if I'm understanding correctly, I think in your analysis, your study, identified lives are those who are identified as poor or worse off, or some characteristic of groups. So we are not really saying that on this particular group of people in front of us who don't have money or something, that kind of identifiability we are not talking about here, but it's a group characteristic. So anyone who shares that group characteristic is in it. So it sounds to me that a bit closer to the representativeness that Glenn was later talking about. And then although theoretically, it's possible to conduct cost-benefit analysis or social welfare function for any policy making. We apply it to the actual concrete individuals in front of you and get the data from them and analyze it. But then oftentimes those methods are used to create the policy for future. So how do we want to weight for those people whose income is low or social class is low? So would you say that here in that kind of method, inherently, are we always talking about statistical lives, or how the identified lives play in? And then in that case, how do you define it?
Yeah, thank you for the question. No, so all these approaches are welfarist, so they focus on well-being. Utilities are a measure of well-being, and then one can model that in various ways. But if one makes well-being a function of not just survival probability, but income and health and so forth, then all of them are going to be sensitive to that as opposed to just the risk of death. So what I meant to say is, if we hold all that constant, right, we consider a population which is identical except for the risk of death for different individuals. What is true about ex-ante prioritarianism is that it prefers to give a unit of risk reduction to someone who is at higher risk of dying as opposed to someone who's at lower risk of dying. So a unit of risk reduction, right, as between, I have a chance of dying of 0.9, Lisa has a chance of dying of 0.5. If I'm utilitarian or ex-post prioritarian, I say, hey, I'm producing the same reduction in expected deaths, I'm indifferent. If I'm ex-ante prioritarian, I say, no, I prefer to give the unit of risk reduction to the person, Matt, who's at higher risk of dying. So that's the particular sense in which this framework has a preference for saving identified lives. The limiting point of that is the case in which my risk of dying, absent the risk reduction, is 1. I'm an identified victim. But the more general feature of this approach is holding all non-fatality characteristics constant, that is wealth and health and whatever, on this one particular specification of the social welfare function approach. There's a preference to focus on the distribution of risks, right, and in particular to deliver risk reductions to those at higher risk, as opposed to simply focusing on the number of expected deaths.
I guess I wanted to make 2 points, or I'm not sure whether they're comments or questions, but one thing that's been interesting to me in listening to everybody over the past couple of days is how many different definitions we have of where you draw the line between an identified and a statistical life. And I think this comes up in the question that was just raised and also in Matt's presentation. If you think that the baseline risk of someone who's middle-aged in the U.S. of dying in the current year is, I think, something like, we're just trying to figure this out, 1 in 10,000, somewhere around there. So that's pretty small. And a lot of these VSL studies look at people's willingness to pay for risk changes that are also about 1 in 10,000, 1 in 100,000. So when we're talking about, for example, in Matt's presentation, the sensitivity of the VSL to baseline risk, in the empirical evidence, we're really talking about very small changes in risk. And the question becomes, how high does your baseline risk or your likelihood of survival need to be before you become an identified life instead of a statistical life? I would argue that at 1 in 10,000, you're probably still in the statistical category, and at 100%, you're definitely identified, but it's not clear to me where the line is. The second point I wanted to make is that I think Lisa raised a really important point that with air pollution, we don't know who would have died in the absence of the policy, just because of the way that the epidemiological research works. But I would take issue with the points about that we don't care about the large number of people whose lives are not being saved. If we did spend huge sums of money on some of these regulations that EPA or OMB has not pursued, we wouldn't have that money to spend on other things, and those other things could be more effective at life saving. So I think that we need to think about trade-offs. And there's also another type of trade-off there, which is that part of the reason we have pollution is because we all want to buy lots of things for not too much money. And if we require more pollution controls, we're going to have to spend more to buy more things, and maybe that's what we want. But I do think we need to think explicitly about how we trade off spending on different types of life-saving policies, and also how we trade off spending on life-saving versus all the other things that we'd like to have.
Yeah, I think those are important points. I think the point about where a person becomes identified is a good one and an interesting question. On the second point about trade-offs, I'd make a couple of observations. One, we never actually take the money we save by not undertaking a regulation and spend it to save lives. We simply don't. We talk a lot about how that would be a good idea, how that makes some rules a bad idea, but we never ever say, you know what, power plants will give you a break because over here we'll make the oil refineries save lives, or over here we'll give vaccines to people instead of regulating power plants. We just don't do it. We just don't.
But we do let that money circulate in the economy. So
That's right, but notice that, and that's your second point. We like to buy things. Absolutely, we do. But imagine the moment if you're trying to think about whether to, again, to go back to the exemplar, I think, for the conference, the little girl in the well or the miners in the mine. Imagine saying, you know what, I really was hoping to go to Target today. And a lot of us were really hoping to go to Target today and buy a bunch of plastic stuff. And so we're going to do that instead of spending the money to save the girl in the well or to save the miners in the mine. We wouldn't be proud of that moment. We wouldn't think, oh, that's a great moment. We've been so sensible. We shifted our resources from saving the little girl in the well to buying stuff because that's what we really like to do. That would be a sad moment, almost a scandalous moment. And so I'm just asking us to think about why it is that when we shift to statistical lives, it suddenly becomes acceptable, even kind of something we're a little bit, like I said, righteous about, to say we're going to shift those resources.
Let me just make one comment about Lisa's presentation. I mean, so I was struck by, it seems to me, and you know much more about environmental law than I do, that there's sort of a hybrid structure. On the one hand, as you pointed out, quite persuasively, environmental law takes account of cost, and we can argue whether that's right or wrong, but certainly takes account of cost in a way in which a policy would not, were we to know for certain that 7,000 people are going to die. But on the other hand, it seems that in choosing between policies, all of which will simply affect statistical victims, right? Environmental law doesn't just take the population approach in the sense of simply focusing on expected deaths. So my understanding is that in various areas, cutoffs are used that focus, indeed, as you talked about, in terms of individual risk as opposed to expected deaths. That is, if one took a purely population approach, then the cutoff would be something like, we're going to be concerned about this waste dump, or we're going to be concerned about this carcinogenic air pollutant in terms of the number of expected deaths, taking account of both individual exposures and the population, as opposed to we're going to step in, if the maximally exposed individual is above a 1 in a million or 1 in 10,000 risk. So there's a sense in which, there's a sort of, and maybe this is just one of these tensions, in which on the one hand, environmental law doesn't act in a way that, government would act were the victims really identified, but in focusing on the distribution of individual risks, it looks more like my ex-ante prioritarian approach as opposed to simply maximizing the reduction in expected deaths.
Yes, hi. I want to thank you all for excellent presentations, but I had two questions, one to Matt and one to Wendy and Lisa. So the question to Matt is, did you shift in an interesting way, perhaps, the focus from the way in which this conference has been talking about identified individuals and identified lives, to talking about the differences among identified lives and how they might show up and what we might do about them. And that strikes me as a different issue from what we were talking about for the most part yesterday. For Lisa and Wendy, I'm interested in the particularly in Lisa's remark that in a certain sense we could look at when we're dealing with statistical lives, it's much easier to talk about death panels than it is about individual lives. And that's how I heard what you were saying, but I'm wondering if you want to comment some more on that.
Yeah, no, again, I mean, it's I think one aspect of any kind of welfarist framework, and again, if one thinks this was sort of suppressed to some extent in the presentation, but it seems to me that all these frameworks are best specified in terms of the distribution of lifetime well-being. I mean, if that's the approach, then, norms, certainly one is going to make distinctions between identified victims, if not on the basis of wealth, at a minimum based on longevity, right? So it seems to me any welfarist is going to say, as between saving someone who is 5 and saving someone who is 85, we're going to save the 5-year-old. But what I wanted to say was, even washing that out, so again, in the simple model that I used, in effect, there are people who are differentiated in terms of their probability of dying now, but if you survive, everyone lives determinately to the same age. And everyone has the same health characteristics. Even washing out these sources of differentiation between identified lives, right? There's this further question, again, do we prefer to give risk reductions to people with higher risk, or do we just care about expected life saving? And what's interesting is that there's a difference, right? That is, it's often assumed that the only way to capture a preference to give risk reduction to identified lives is by becoming non-welfarist, and that's not true. I mean, my framework is welfarist, right? And so, and this is my larger project, which is, we can talk about, we can capture preferences for equity and various kinds of non-utilitarian normative preferences within the ambit of welfarism, right? So in particular, here, by using this ex-ante prioritarian approach.
In answer to your question, I think it becomes easy to talk about a lot of things and about death panels and other possibilities for losing or sacrificing lives when the lives are statistical. I absolutely believe that's true. I believe also that people who are in the business of encouraging the trade-offs that we've talked about between money and lives trade on the concept of statistical lives in order to reassure people that they're not doing anything nefarious. Some years ago, I was at a conference in which the concept of EPA's then senior death discount came up. EPA had quietly started to offer a different value of life for people over 65 than for people under 65. And this was a topic at the conference, and the person, an economist, a fan of cost benefit, stood up and said, you know, what we really have to remember is these are statistical lives. And that just puzzled me. Well, all right, then what do you exactly mean? Are they lives? Are they human lives? What exactly are they? What do you mean by that? It was a way of, the adjective statistical was a way of explaining why we can treat these lives differently, either outright killing them or discriminating against them, some manipulating our analysis of them in a way that we wouldn't do with real lives. It's very, very comforting to use that adjective statistical when you're in the business of not protecting everybody.
I agree that. I just want to add another variable that I think we haven't talked as much about. We've talked about statistical lives. We've talked about the social welfare cost benefit trade-off, the dollars. But as I think about public health law, at least, there's another factor, which is that all risks that are equal statistically, if I could put it that way, are not treated the same in our law, in our society. So, you know, if I go back to the smallpox example, the risk of smallpox might be exceptionally low. And in 2003, this country spent a lot of money ramping up a smallpox vaccination plan, and everybody knew that the risk of smallpox reappearing was exceedingly low. It wasn't just that, well, it's low risk, high probability. It also had to do with the dread, the fear factor. There are fears and dreads that are culturally magnify risks, even to statistical lives, that other risks, and one fact, that other risks, same actual risk, you know, probability of risk, we just don't fear as much. We tend, I mean, the literature tends to show we fear new kinds of risks more. We weigh new things, right? So smallpox at one point was not so fearsome, it was endemic, but the return of a dread disease, or, I mean, we've all seen the movies, you know, the endless Contagion, right? The fear of something new and dreadful has a much greater resonance than its actual probability or its cost. So there are some other factors that go along too.
Wendy, can I just push you on that last comment? From your perspective as a public health lawyer, would it be better if we try to debias against those kinds of concerns? Or do you think that that's sort of, and this was a question that came up in yesterday's discussion, whether the disutility we experience from that even if it turns out as a matter of pure efficiency not good to spend on the smallpox, that really the comfort we take from that, even if irrational, is kind of desirable?
I don't have a perfect answer for that, but I think that we do go too far. And certainly the history of public health law, and I think of our own laws, is this tendency to go from, you know, the fear du jour, the catastrophe that's looming at the moment, and we go from epidemic to epidemic. There's a very robust literature about the phenomenon of the emerging epidemic literature, and we're constantly sort of ramping up against the new fear and overlooking the existing and chronic and endemic conditions. And when I'm talking about public health law, here I am talking about something where there are very clear trade-offs, where actually we're talking about health agencies putting particular resources away, for example, away from childhood asthma or diabetes and into smallpox. And I mean, there were definitely studies. There were dollars diverted. So I do think it is a danger.
I have questions for Matt Adler. Initially, some suggestions or questions about how he would elaborate the framework, and then afterwards a criticism. So there are various ways in which the idea of ex-ante prioritarianism or ex-ante any distributive pattern can be cashed out, and I wonder what you have in mind. So firstly, of course, you know more than any of us about the different interpretations of probabilistic terms, and I wonder if you mean by that epistemic or any other sense of probability for today's purposes. Here are some other questions about that. So one is, often when people focus on chances, not on outcomes, it comes with the individualistic baggage. So Peter Diamond's classical article has individualism in the title, and the idea is it's fair. Maybe it would have been nicer if we had some other distribution, but it's fair towards Alex not to just hand it to the other person, but rather to give Alex a chance. Do you think that this framework has to be anchored in such an individualist obligations towards people framework, or it can be kind of neutral in that way? Another question is, a lot of people don't want the currency of distributive justice to be welfare. They want something like access, resources to, access to welfare, resources for welfare, and things of that sort. When you try to add to that chances, you realize immediately that there are two ways of doing it. So it can be either everybody will have we think about the prospects for, say, access to welfare, or it's access to a good chance for welfare. Which of these ways should people with a sort of egalitarian bent go? All right, I'll quickly deliver a critique, and it's something that I think we discussed during the break, and I actually sent you that critique when you were still writing the book, but you're still holding to the view. So think about the Peter Diamond example. We can either, we have like somebody will be here, and what's better, flip a coin or just hand it to Alex? Think of a permutation on that example. Either we hand it to Alex, the good to Alex, and Alex is here, and the other person is here, or we flip a coin between them. Each has an equal chance of being the winner, and both positions, or at least the position of the worse off one, is ever so slightly lower. I think the intuition for most of us will be that the equal chances is worth it. It's just a small loss in utility. We're sure to lose in terms of the goodness of the outcome. The worse off will be even worse off. And yet, the intuition that people have is that because equal chance or priority about chances matters as well, it's just worth it, it's fine. I don't see from that point of view why the fact that the outcomes, when you take ex-ante considerations into account, why the fact that the outcome is sure in some scenarios to be worse is such a devastating answer to the people who hold that view.
There's a lot we can talk about. Let me just answer briefly the first four questions, and then maybe get the slide back up and try to provide an answer to the last. So in terms of whether the probabilities are epistemic or non-epistemic, I mean, ultimately, the question is for a policymaker, what should I do? Right? Now, I might be omniscient. I might know for certain what outcome is going to happen, but if not, I have to decide what to do, and so it's natural to think, well, I think of different choices as being different probability distributions over outcomes. So it seems to me necessarily, insofar as the view is act guiding, those are going to be epistemic probabilities, right? Those are going to track your beliefs or rational beliefs that are accessible to you by revising your actual beliefs. So they're ultimately epistemic. Now, but there are various ways to cash out epistemic probabilities. So we can cash that out in a Savage-style framework or some other framework. And of course, as risk assessors know, your epistemic probabilities, that is the degree of belief you ascribe to different outcomes, is going to be sensitive to observed frequencies. I mean, the whole point of statistics or Bayesian statistics is to tell you how to update your epistemic probabilities given frequencies. The frequencies are going to be part of the story, but at the end of the day, as I see all these frameworks, whether it's ex-ante prioritarian or ex-post, what have you, the relevant probabilities used to come up with the probabilities of outcomes and individual expectations are epistemic probabilities. I do think these views are ultimately individualistic. That is, they focus on the distribution of individual utilities or expected utilities. they're not atomistic in the sense that an individual's utility can, in theory, depend not just on her own characteristics. I mean, for simplicity, so in all these models, we often start by saying, well, someone's well-being depends upon her own income, her own longevity, her own health. But, you know, their utility might also depend on relational characteristics. So, for example, having less income than others in the population one could have a utility function that takes account of that. One could even have utility functions such that, which is kind of recursive. So your utility depends on the distribution of utilities, and you sort of permute that until you reach an equilibrium. So, but ultimately, at the end of the day, these are individualistic frameworks in the sense that we map outcomes onto utility vectors, capturing each individual's well-being, more or less complexly determined, and then rank outcomes and policies in light of that. Yeah, I mean, as I say in the book, you know, at the end of the day, we want a framework which is sensitive to individual responsibility. So if, you know, the two outcomes, and in one outcome, people are at the utility levels, you know, through bad luck, and in another outcome, we have the same realized utility levels, but some of the people who are badly off are responsible for being badly off. They were, you know, reckless or whatever. We'd want to distinguish between those two, and welfarism doesn't do that. So I view this, you know, the social welfare function approach as one step on the way to what Dick Arneson calls responsibility-adjusted welfarism, and I talk in the book about how to do that. Yeah, chances, again, I mean, outcomes can be more complexly determined, so one could have a kind of ex post approach such that in characterizing outcomes, you talk about not just people's, you know, realized longevity and income and so forth, but what the opportunities were, you know, at various points in time. So so it might be that a life history for someone includes not just, again, you know, attributes during different periods, but the options that were open to her, and that in theory could be part of her utility. So let me just, in terms of the example that it's not exactly the same slide, but it's, you know, just to use this slide. So I mean, what I'm going to say, you know, focuses on this slide, but it applies to the example that you were discussing, which is not Diamond's example, but a permutation example in which we equalize chances, and in each state we subtract a little bit, right? So the ex-ante prioritarian, or your approach, recommended approach, a hybrid approach, right? So I should say, so one way to care about the distribution of expected utilities is just, you know, ex-ante prioritarian. Another approach, which sounds like what you're proposing, is a kind of a hybrid where you give some weight to this distribution, right? But in any event, here's the puzzle. If you're going to choose this, you say this is better, right? Because expected utility is better. Why do I think that's perverse? Okay? Imagine that you were omniscient and that you knew the state was going to be A. You would definitely choose this, right? You definitely choose this. I mean, assuming you're impartial, right? Imagine that you're omniscient and you knew the state is B. Again, you definitely choose this, right? Because you can understand, if the state is A, this is a better outcome. If the state is B, this is a better outcome. So but as it turns out, what pushes you to this is your ignorance about what the state is, right? But you know that whatever the state turns out to be, this is going to be a better outcome. And Mark Fleurbet has sort of recaptured that in I think, an even more persuasive way. You know that. Imagine you had an omniscient advisor. That person will either know the state's going to be A or know the state's going to be B, right? So you know that your omniscient advisor would tell you to pick this, because that advisor is going to know what the state is, and whatever the state is, this is a better outcome, right? That's why I think any approach that violates weak stochastic dominance is just perverse. But again, this is a much broader conversation. The literature is split on this. The bigger point, I don't want to get lost in this forest, is, I agree with Lisa and other skeptics of cost benefit that standard cost benefit, simply adding up willingness to pay, calculated by multiplying risk reductions by TSO, is very problematic. However one resolves this approach, one would want to do cost benefit with weights, and then whatever side we come out in this debate, we can come up with appropriate weights. Right? So this is an intramural dispute within the family of people who agree that the better way to do cost benefit is by applying one or another weighting scheme.
Right, so This is a question to Matt. This is about the connection you draw between ex-ante prioritarianism and a focus on identified lives, identified deaths.
Right.
So sometimes the way you present it is simply by virtue of the fact that an ex-ante prioritarian cares about, say, raising the odds of a good outcome for individuals, or raising someone's expected utility. That implies a sensitivity to identified lives. But really, it only implies such a sensitivity if, in fact, as is actually the case, it's sometimes true of people that either they're certain to die or certain to live, or some other outcome is certain. I mean, if outcomes are never certain for individuals, right, then we never have identified, let's just focus on death and life.
Right, right.
I mean, if it's never certain that for any individual that he'll live or any individual that he'll die, we don't have identified lives or deaths, right? I mean, all we have are populations, right, that we're part of. And it could be that, you know, the chances that an expected ex-ante prioritarianism cares about is purely a statistical chance, right? And we may not know for certain how many people are going to live or how many people are going to die, and the chances are just a matter of, you know, to say that someone has X chance of living might just be a matter of that person belonging in this large population about which we have certain statistical information. But if we were never certain of anyone that he would live or die, well, you know, an ex-ante utilitarian is going to be able to make all of his calculations and recommendations, and we're just not going to have any concern for identified lives. So it's only in these sort of, I mean, limiting cases that we actually have any concern for identified lives.
I don't think that's right. That is again, in this model, this shows the social value of risk reduction, right? The increasing social value per unit of risk reduction for the different approaches. And what you can note about this is that for utilitarianism and ex-post prioritarianism, the PI, that is the individual probability of death, is no part of this expression. So insofar as under these approaches, you're going to prefer to give a risk reduction to this person as opposed to this person, all that's going to influence that as well. Here, I mean, this is pretty complex, but the social value of risk reduction depends both upon individual wealth, but also this expected utility term. And so probability affects that. In particular, what this means is that not just where the person is sure to die, but even if they have a higher chance of dying, ceteris paribus, that's to increase this. You can see that in this slide.
I think I don't disagree with you.
Yeah,
I mean,
yeah.
I agree that that's what the ex-ante prioritarian.
But the other point is it's not, I mean, so in this, I mean, I manufactured this so that Dan, you know, here has, is sure to die in the period. But if we added another state, right, where, let's say we add you know, state Z, where all live, right? And that's going to, you know, increase Dan's probability. So now he's simply a statistical victim, right? He dies in these states, but not in this state. There's still going to be the preference under extended prioritarianism for choosing this as opposed to this.
Yeah, well,
right?
yeah, I think my point is, well, there is going to be, you make it sound like this concern for reducing risks to individuals is in fact a concern for identified lives or identified victims. But that's only the case when we ever have victims who are certain to live or die, right? So, I mean, when you introduce this possibility, then the concern isn't actually any longer a concern for identified lives or deaths.
No, fair enough, yes. There's a more general point, which is that the ceteris paribus ex-ante prioritarianism, because it focuses on the distribution of effective utilities, and because it's egalitarian, prefers to give a unit risk reduction to someone who's at higher risk. A limiting implication of that is the case of identified victims, but that's simply one implication of a much broader feature of the view.
Right.
Yeah,
Okay.
that's right.
There'd be a lot more to ask Matt, but I want to ask a question to all the lawyers about something quite different. So this is a very naive question from someone who doesn't know a lot about the law, but so here goes. So in public policy, we often have situations which have the following features. So we impose a small risk of harm on each member of a large population and can thereby foresee confidently that the incidence of this kind of harm at the aggregate level will rise. But even after the harms have occurred, we cannot know which individuals were adversely affected by our decision. So let's just give an example. Say we're the Minister of Roads and we have to build a new motorway between two cities, and studies tell us that road design influences the number of accidents and people's likelihood of having an accident. In particular, on roads which are just straight, people are more likely to speed and have accidents, and they're also more likely to fall asleep and have accidents. So we have a choice between the straight road and the long and winding road, and let's say we decide for the straight road. So, as predicted, the incidence of accidents on that road is higher than on comparable roads of the other type. But so it's clear, we've caused an aggregate effect here. But now let's ask, for which individual accident that happens on our road are we responsible? And it will seem that looking at any individual case, there are always other explanatory factors which are far more powerful than the straightness of the road. So for someone who fell asleep, probably hadn't slept enough the night before. For someone who sped, he wanted to impress his friends, And in each of these individual cases, the fact that the road was straight is relatively unimportant in explaining why this particular accident happened. So we cause an aggregate phenomenon, but it seems problematic to say that we're responsible for any of the individual events that together make up the aggregate phenomenon. So my question is, from a legal perspective, say we wanted to sue for compensation, or we want someone to be held responsible for what's happening on this road, what is more important? The fact that we can say that the decision caused an aggregate effect, or the fact that it's problematic to say in any given instance that we're responsible for a bad individual outcome?
Maybe I'll take the first swing at it, just to say it's complicated. Basically, there's a set of doctrines in tort law relating to causation that's relevant to here, right? You need to show that my lack of reasonable care, my breach of a duty to you, caused an injury. Well, it turns out to be complicated what that means. There's a whole doctrine known as loss of chance. So, and there are differences about recovery. There's also a separate doctrine about contributory negligence and comparative negligence, where it may be that we were both at fault, it caused it to us, and in some jurisdictions, only if I'm more than 50% at fault can you recover against me, whereas in other jurisdictions, we're going to parse things out and say, I was 25% at fault, and this can be true for causation as well. So one possibility is partial recovery, that I should be recovered for the loss of chance. But in general, one of the problems of the tort system, one of the features of the tort system is negligence in the air is not enough. If I do something that puts you at increased risk, ordinarily, unless you've suffered from that risk emotionally or something like that, unless the risk materializes, you have no right of recovery. So systematically, we're going to undercount. We're not going to make the actor fully internalized. So that's a bit inchoate, but just attempt to try and show you that it's complicated and probably also depends a lot on the subject matter of the litigation at issue. I don't know if you guys wanted to.
I want to add, I guess I totally agree, but the tort system has this way in which it has a lot of trouble dealing with statistical harms in that sense, even to identified lives or multifactorial causations. And it has this sense of, it's, we pretend almost, we go through the black box of the jury, and the question becomes, it's either it caused it or it didn't. And it has, although there will be contributory negligence and then reduction, but it has this sense of, if it's not more than 50, right, we can't compensate, except in loss of chance, which is pretty limited doctrinally. We can't compensate a 0.5% chance, even though we know it's 0.5. But the other thing I just want to quickly add is the doctrine that I dealt with, for example, the public duty doctrine, is a way of saying you don't even get to a jury, because there are situations in which the evidence may be difficult to show causation, but there's a deep skepticism within the legal system that juries will get it right from the legal system's perspective. And so the no duty rule is a way of saying you don't even get to the jury in these cases. It's just purely discretionary. The the state can design the road any way it wants, and it doesn't matter, even if you could show 100% probability of causation, we're not going to let it get to the jury, because we don't trust, in a sense, that the jury won't won't skip from 49 to 51%.
I take it you're not a lawyer? Is that from
no,
the
I'm a
question? Yeah,
philosopher.
yeah. But it's a great question, so you should come to law school. And you should take my first-year course on the regulatory state. That is, the sweep of that course takes risk as its problem. And what students discover in the first weeks is how inadequate the common law is to dealing with the problem you identify. That is exactly as Glenn says, it has a very difficult time when it comes to risk. You end up thinking, which is what your example suggests, that in fact nobody was killed as a result of the design of the road, and yet you have evidence that they were, but in any individual case you can't say that they were. And that problem is part of what led to the regulatory state and the environmental laws I described. And so absolutely the law looks in two different directions on this, and one of the reasons we have EPA is because it doesn't do well with the example you described.
Thanks a lot.
So a comment on something Wendy said, and then a possibly provocative question for Lisa. So the comments, Wendy, in the discussion you mentioned the difference between the perception of risk and the fear of risk, and the idea that sometimes we react to very small objective risks because we're afraid of them. And you use the example of smallpox. Well, are you afraid of smallpox, really?
I didn't hear you.
Are you afraid of smallpox, really? Is it your fear that makes people like us think that smallpox is something that shouldn't be tolerated? I mean, I think one of the problems with a lot of literature on the regulatory literature on risk and legal and economic literature is it doesn't really pay much attention to the causes of the risk. That is, it takes into account what the risk is and the probability, and it considers the fear as well. But in a lot of cases, I worked on railway safety, which is an interesting issue because there, the risks are tiny. No one is afraid, really, of getting on a train. No one thinks of the train crashing when they get on. But nevertheless, we treat railway safety with a huge amount of over-regulation all around the world, relative to the standard cost-benefit analysis. And looking at different cases and looking at people's reactions to different crashes, I mean, it seems to me that the issue of blame and responsibility is very important here. And particularly where you can trace back the cause to the agency that's meant to be guaranteeing our safety in the first place. And so if there is an epidemic of smallpox again, it will be because the vaccine has got out of it, the virus has gone out of the laboratory. So the people who were there meant to be the custodians of our safety are causing the problem. So I think that we have to look at these issues of responsibility for causing the hazard as well as the hazard itself. So in the railway case, for example, the railway companies are very worried about the safety of their passengers. They're much less worried about the safety of trespassers, even though from the point of view of the probability analysis, you might think that they ought to be paying more attention to the trespassers because there are probably something like 20 times as many trespassers each year that die than passengers. Right? So certainly there's a commercial imperative for the railway industry to pay special attention to the passengers. Whether it's a moral imperative to do that, I'm not so sure. So in any case, this is a plea for thinking about also the cause of the hazard and not just its probability and whether people fear it. Because I'm sure that our perceptions have got this third quality to them as well. So Lisa, so one sort of mean-minded way of taking your talk is to say that there's a discrepancy between law and policy, or environmental law and policy. And environmental law says we should be cost blind. Sometimes when these regulations go up to the highest level, they're turned down because of the cost in a way which is benefit blind. So isn't it really time for a Hegelian synthesis here? And that we should take into account cost and benefit and just do standard cost-benefit analysis, and that way we can tie up both sides, because the problem is that both of them are only looking at half the picture.
Do you want to answer? Or was that simply a comment?
I don't know if that was a comment or a question. I agree. I mean, actually, my point about smallpox was, I think, similar to what you're saying, is that all risks are not weighted in law or policy or culture equally, all risks of equal probability because of a variety of factors. And when I was saying we fear some more for all kinds of reasons. Some has to do with novelty, some may have to do with deep cultural aversions and dreads. Some have to do with senses of responsibility. I mean, part with the smallpox, yeah, there was, right, if we go back to 2003, it was very much tied up with the fear of terrorism. And, right, so fear of death by terrorist in the years following 9/11 was certainly treated with greater weight than equivalent risks in terms of probabilities of death. And it has something to do with responsibility, it has something to do with all kinds of cultural and social resonances.
So I agree with that. I would just want to say it's not all mediated through fear. So that in the railway case, for example, that fear may have increased for about 2 days after a crash. Then it goes back down. But blame doesn't. So you have social amplification of fear, which is one phenomenon, and then social amplification of blame. And that seems to be much more persistent and a different phenomena to fear. And it doesn't have to go through fear in the first place, I think.
I don't think your question is mean-minded at all. I have two observations in response. One is that even when we do cost-benefit analysis, and for those of you in the back, this is in scare quotes, when we do cost-benefit analysis, in many cases it becomes simply cost analysis. That even in the case that I described, there was a quite extensive cost-benefit analysis, but at the end of the day, the thing that mattered were the costs. So I don't know how you get around that problem. I really don't. And in fact, what I saw in government was a little bit surprising. I had spent a lot of time critiquing cost-benefit, and that sort of is done. I think cost-benefit is here. But even with that, what I saw is that critique was in some sense off point simply because it wasn't the cost-benefit analysis that made the difference. You could speak in those terms maybe and justify the decision, but it was something different outside of the cost-benefit analysis that actually was decisive, and that was striking to me. The second observation that I would make in response to what you say is what I think we haven't done enough of is to have a real justification for staring the lives in the face, as I said, so to speak, their statistical lives, and saying, no, we won't protect you. No, we'll let someone else harm you. And we can have all the fancy ways of describing that we want, but that is a solemn moment. And especially if we think that there is a duty when the lives are identified, then we really have to explain why it changes when they're not.
I'm not a lawyer, but I'm fixated on the straight road and the curved road. And I'm thinking about bringing a case in two different ways, and I'm just curious about whether there's any implication in the difference. Let's say that it was predicted on the basis of excellent evidence that there'd be a 15% increase in mortality, and 100 people have been killed. So Mr. Jones comes to me and says, would you represent me? I lost my spouse, and I want to claim damages. What was said is, I'm very unlikely to win that case because perhaps she didn't get enough sleep the night before, et cetera, et cetera. Then I get the bright idea, suppose I identify all 100 survivors and offer to represent them and bring a case in which I argue I cannot identify the specific individuals in this group of 100 victims, but 15 of them have been bereaved by the choice of the straight road, would that make any difference from the perspective of precedent and I suppose speculatively imagining of how juries would respond?
Go to the class action? I mean, there was a period of time where the answer might have been possibly through the class action mechanism. And when we talked a little earlier, I think Betsy talked about changes in doctrine. I mean, the courts over the last 20 years have made it made it very difficult to bring class action cases in, class action tort cases. And we've seen this in the smoking cases in particular. And so you get a rejection now, by and large, of the idea that if you aggregate a class, a population, and you know that, right, you have very good epidemiological evidence that the defendant's action has caused harm to the population, but you cannot show, for example, that the risk to any one person who was injured was more than 50%. By and large, now you cannot bring the class action mechanism, and it will be very hard. There was a very interesting, and I'm having a forgetful moment right now, case by the First Circuit just a few weeks ago, though, that allowed, not in a class action, but allowed a plaintiff in a toxic tort case to go forward and use a more holistic approach to causation without relying on showing that the relative risk to the individual plaintiff by the defendant's action was more than 2.0. There had been many courts that have said epidemiologically that unless the relative risk was more than 2.0, then no one individual, no matter what, could ever bring the case, which goes back to the problem, right? You have 15 people, you know 15 people who die, but 100 people dead, you know 15 of them were caused by the straight road, and nobody could bring it. The First Circuit actually said, well, maybe it could go to the jury in some of these cases if you have enough multiplicity of different approaches, and expert testimony can then jump you over the hurdle. But it's very hard, and class actions really are no longer viable.
The only thing I'll add is just to be a little more sympathetic to the defendant in this case, that one of the problems is, imagine that 15 of the 100 have really suffered, right? We don't know which 15, right? You can't really force them to join their case together, right? So if all 100 sue you, there's a good chance that some proportion of them, more than 15, will benefit. I mean, it gets complicated here, but there is a way in which you might think the solution would be partial recovery for all 100, dividing the recovery of 15 people between 100 of them, but it's hard to force that in the court system. Betsy, you wanted to say something on that? Yeah.
Can I just say something about
Yeah.
employment in that context? Because in employment discrimination, in the period when the courts liked civil rights law, they used to actually do formula relief and take the whole class of the 100 and say, well, we can't really figure out who would or wouldn't have gotten a promotion, so we'll do it by formula, and we'll give everybody a percent, and it's rough justice. So guess what? In the same Walmart case where Scalia put the court speaks down class action, he also speaks with withering scorn, most Scalia-like, of this unheard of thing called formula relief, which had been asked for, which wasn't at all unheard of. Used to be regularly done, but Scalia, who doesn't like employment discrimination law, spoke of as if it was just a horrifying idea.
Yeah,
Right.
and this was very close to what we used to have in tort law for a while. We had it in the DES cases, the so-called market share approach, where it was a different kind of scenario because you knew the plaintiff could show pretty much 100% that the product caused the injury, but which manufacturer. And in those cases, the court really did allow what is in effect statistical recovery, right? A recovery based on the statistical market share. But the courts have been very reluctant to extend that approach beyond a very limited set of fungible products that are, I mean, there really is a reluctance to sort of embrace statistical relief, because that's what we're really talking about.
Well, I'm not sure where I'm dragging this exactly back to maybe an ethical question. I work for an institute that's funded half by EPA and half by the motor vehicle industry worldwide. And so my question really gets to when the issue of, say, smallpox and environmental issues kind of become one and the same. And my example is that it's very easy in environmental law to blame the manufacturer, the evil industry, and so on. In the car company case, they certainly deserve some blame for having been dragged kicking and screaming into air pollution reduction. But we're now approaching this time when we have reduced emissions from cars by like 99% and more, and it's extraordinary the changes that have occurred over time, such that what drives air pollution a lot of times is vehicle miles traveled. The fact that we as individuals can't or won't get out of our own cars, in part because of other public policies that have to do with land use planning and other things like that. And we know from studies that what you do in your own car doesn't stay in your own car. I mean, how you're affected by pollution on the road is affected very much by any other technology that's out there. So we all have a part in this role. In the same way, we all have a part in needing to be vaccinated so we don't put the rest of the population at risk. And so my question is sort of, how then where does personal responsibility come into this question? Because it's easy to sort of say, oh, we ought to stare down the face, talk to the victims, and as if it were, though, that it's the car companies who really have to look at those victims and say, we're not going to protect you, when it's really, all of us in this room.
I think that's a fair point in a way. I think that we do engage individually in polluting behavior. I think that the risk that we impose is smaller than the risk collectively imposed by the manufacturers. But I think it's a fair point that we impose risks on others. On the other hand, the car manufacturers decide what vehicles to make and market those vehicles. Those vehicles, it's not like people simply say, oh, I think the consumers demand a sport utility vehicle. That's what they really want. And the manufacturers simply respond passively to that demand and say, oh, okay, I guess so, right? Okay, we'll make sport utility vehicles. So it does seem to me that there's a large amount of responsibility on the manufacturers, and they create demand for products that otherwise maybe wouldn't be even sold, it seems to me. So I think it's some of both, but I wouldn't leave the manufacturers behind by any means.
This is a comment on Lisa's presentation. I don't think there's any question in it. If you can find one, fine. But I was initially very heartened by your presentation, because I've long thought that we have a bunch of irrational environmental laws which tell us not to pay any attention to cost, and they are maximally protective, and that doesn't seem to me to be rational. And the way I heard your presentation was, well, yes, we do have those laws, and probably because Congress isn't very good with dealing with these issues. So we do have those laws, but fortunately, there are other parts of the political process, like the fact that it has to go through OMB with a cost-benefit analysis, and then it has to go over to the White House and can get turned down there. So I thought, well, that doesn't sound like a bad way of dealing with the fact that out of Congress we get at least what I would view as irrational levels of protection being asked for. Now, the only thing that then in the discussion made me a little less heartened by your presentation was the fact that when you said when it gets to the White House, well, I'm not sure whether this would apply to OMB as well, it's no longer cost benefit, it's just cost. And then that doesn't sound like as good a solution to the problem, but at least it still is better than if we simply followed strictly those pieces of legislation which ask for maximum protection.
I'll treat it as a question.
That's fine, but
Yeah.
I mean it only as a comment.
Yeah, I understand. May I comment on the
Please,
comment? Yeah. Which is that I was trying in my remarks, although I think probably my views come out some, but to be really descriptive rather than normative. That is, this is what, there's slippage between the promise of the law and the law in action. And regardless,
That's a good thing.
absolutely. And what I'm saying is, you may well think that, but it makes the law a lie. And I don't think that's a good thing.
Wasn't there a little bit of a normative side remark, though, that Dan ought to be thinking about? That I think echoed this very striking example you put in your book about the California talking on the telephone law. Mm-hmm. Okay, so this is the Keller-Hicks business, right? So what you said was, you just muttered this really as you were talking. You said, when we say that this doesn't meet the cost-benefit threshold, we require, we say, okay, well, we won't offer this protection, and we're kind of proud that we do this, and you heard Dan being proud that you do this. But we don't, yeah, no, you do. But we don't turn around then and say, okay, well, we'll protect in a more efficient way by using this money for something else. You just leave it there. And so what you get is no protection, and who knows, implicit in what you said was, who knows where that money is being spent? You mentioned buying plastic things at Target. That could be one use. It could be a lot of uses, but if what we were saying was, no, this doesn't offer enough protection to justify the expense, then should we apply this, how much protection is the alternative use then buying us? Is that the criterion we should be using? And if not, why not? So, for people who haven't read your book, in California, please correct me if I got this wrong, the question was put to the legislature whether or not they should ban talking on cell phones when you drive. And there was a couple walking by the side of the road, elderly couple, I believe, and a car driven by a lady who was talking on the phone got out of control and killed them, or injured them or something. And so later on there was a lawsuit, and forget the lawsuit, when people looked at this, they said, okay, is this the kind of problem that warrants regulation? And the test that was applied was whether the value of being able to chat on the cell phone as you cruise down the highway was sufficient, and whether the number of people who would enjoy that was sufficient, so that the total value outweighed the loss that might come about from the occasional pedestrian or other person who would be killed as a result. And since they judged that the former did outweigh the latter, the conclusion drawn was, don't ban talking on the telephone. Now, what was the net result of this? Well, probably the predictable amount of mayhem. But it's not like anybody got compensated. It's not like they said, no, look, we can switch the money, the value that the talkers are enjoying, and fully compensate the losers here and have money change left over. So that's what we should do. I mean, that's sort of the theory behind it. But they didn't do that. They just allowed all the enjoyers to keep their enjoyment, and the losers kept getting maimed, right? So there's this remainder when we think this way. And so Dan took you to be praising this system. Based on your book, I would think that if you laid your real cards on the table, you would have said you were condemning it.
Fair enough. Yes, I would. I continue to hold that position. I've lost.
But let me just say, I mean, again, it seems to me one can be in favor of balancing. I'm much more in favor of balancing than you are, and still be quite critical of cost benefit as it's actually practiced now for various reasons. I mean, let's not lose sight of that. One, and this is suggested by some of your remarks, I mean, cost benefit, at least as it's currently practiced, looks at people's actual preferences. And you might say, in a consumer society, in a society defined by consumption races, people, in actuality, put much too much weight on income and consumption as opposed to other things, and if we were to correct their preferences in various ways or to wash out various kinds of pro-consumer social norms, they put more weight on health and longevity and less weight on target. I mean, part of the point here is that your life is really not much better if you got 1,000 widgets from Target as opposed to 500, right? So, and part of the problem is that cost benefit in its current form takes actual preference satisfaction to be the measure of well-being. One can believe in balancing and not believe that. The second point, which in a way was part of the point of my presentation, was that even, orthogonal to that, even if one sort of defines well-being in terms of actual preference satisfaction, cost benefit simply sums up these willingness to pay amounts without weighting. In effect, cost benefit gives an extra advantage to people who are better off, right? So if you're better off, you're likely to, want to spend more on health, want to spend more on avoiding discomfort and so forth. And cost benefit inflates that. It inflates that indeed beyond the point that a utilitarian would, because cost benefit means that valuation is inflated by the fact that your utility of money declines. And it certainly inflates it beyond the point that a prioritarian would. So it seems to me one can basically, agree with Dan that balancing makes sense, but take issue with the way that cost benefit is performed in theory, and certainly take issue with the way it's performed in practice, given the way what Lisa said, namely that it's just a matter of cost.
Can I just say one thing? Not being an economist or a philosopher, the practicing lawyer in me says the other thing we're forgetting about is in practice, the burden of proof. And when you put that kind of burden on a regulation, you're requiring a certain amount of evidence and a quality of evidence that in the real world, it's really hard to get, and it's particularly hard for those who are supporting regulations to get against, in many circumstances, very well-vested interests that are much better able to amass the evidence countering it. So where you put the burden on proof and what kind of evidence counts and who can get it can make all the difference in the world, because abstractly, these things, the cost benefits may come out in certain ways, but how do you actually prove it? Where do you actually get the numbers?
Let's take this as the last question, then we're going to have to break. Go ahead.
Quick response to Dan.
Or not. Go ahead.
It's not clear to me that even taking into consideration cases like you raised, that all things considered, it may still be better that there's the kind of leakage you pointed to than if there was no leakage and we had to pay the cost of maximum protection laws that didn't allow any consideration for the opportunity costs of those.
Okay. Let's leave it at that. Go ahead.
So another comment from a naive non-lawyer. I'm a philosopher, so pardon me. But so I want to go back to. I fully understand that pragmatically, whether you do something through the tort system or through regulation, these are kind of fungible. You could aim at the same result. One is more efficient for a certain purpose. But still, I want to go back to perhaps a discredited old-fashioned notion between public law and private law. And there may, in fact, be a very important conceptual division of labor between the sorts of things that you want to take care of under private law and under public law. And I want to attach it to a very important distinction that Tim Scanlon makes about kind of confusion that we have in the idea of responsibility. There's responsibility as attributability. It's connecting up through the causal chain and through a chain of intention a certain kind of consequence to my actions. And then there's what he calls substantive responsibility, which is where should the burdens fall? And he shows, I think, rather convincingly that one thing doesn't necessarily follow from the other. We may choose to indemnify each other against burdens quite apart from the question of whether or not we are, we are in the causal chain or in the morally responsible chain. And so here's a kind of a very crude distinction. Private law of torts actually focuses in on holding people account for the things that they have intended and caused or have been negligent about. And public law takes care of this other idea of just deciding on other kinds of philosophical grounds when we should indemnify each other from harms and when we shouldn't. And so it's not a surprise at all that you get these very different kind of regimes and different ways of thinking. There's a prior philosophical question that we have to decide, which is, of the sort of harms that we're talking about, are these the sorts of things that we should indemnify each other again, quite apart from contributory negligence or quite apart from our actions, or not? And that's a philosophical, a political philosophical decision to be made. And once we make it, then it shouldn't be surprising that if you're simply looking at lives saved, you'll get very different results whether you send things through the tort system or you send things through the regulatory system.
So let me take a first stab at this, which is more sociological, which is to say in contemporary tort discourse, there is a split between people in law and economics who think of tort system as merely one system for indemnification, redistribution, shifting of burdens, obligation, inducements to care, but not particularly distinctive, right? And then people in the corrective justice world or the civil recourse world who think that there's something very dyadic, very specific, and that this is just really just a gulf between these two. In the law and economics, regulation and tort look very similar, public and private law look very similar. If you're someone like Jules Coleman or my colleague John Goldberg, in fact, tort has a theory to it as a distinctive body of law. And so I think probably the question about whether this is a relevant distinction depends a little bit on who you ask amongst that. But other people might have more substantive kind of stuff they want to say on the subject.
I think I disagree about the divide, at least when it comes to environmental law, and there may be other regulatory subjects where this wouldn't exist, but it has always struck me that in environmental law, we know enough, at least today, we know enough to attribute harms to specific facilities, and at those facilities, decisions are made by humans about exactly what activities will be undertaken and what controls will be used. It strikes me as following in the same ethical path that tort would take. It's just we can't identify who's harmed at the end of the day. That strikes me as the large difference. Not that people aren't making decisions that lead at the end of the day to people being hurt, but we can't tell who it is. So it's always struck me as really important in environmental law to maintain that ethical underpinning. It's usually lost. It's often lost. Maybe it's rightly lost, as you're suggesting, but to me, it's there.
Let me, I mean, you're certainly right that there's a distinction, but, you know, it seems to me at the end of the day, now one might think there's sort of a separation between political theory and moral theory, but one view is at the end of the day our political and legal distinctions are accountable to moral distinctions, right? So if one's a consequentialist, this distinction makes no sense, right? A consequentialist is going to say, I want to impose liability or, you know, put in place regulations in terms of maximizing good outcomes going forward, whether utilitarian good outcomes or what have you. But what's interesting, in a way I think Lisa is saying this, is that even within the, you know, the space of a non-consequentialist view, right, one could have a deontological view which says, you know, what's really important is to stop people from actively killing. Now, obviously, in a case in which, you know, I actively kill someone in front of me and it's clear that, you know, my responsibility ex post can be apparent, we want that to stop. We also want to stop cases in which I'm going to for sure actively kill some people, even though down the road they're not going to be able to show that I was the source of their death, right? And if that's right, again, the focus on of the private law system on the plaintiff being able to show the defendant's responsibility for her harm becomes problematic, right? So one needs to try to justify this distinction, it seems to me, in light of some, you know, some deeper moral view, and it's not clear to me that even if one sort of goes deontological, that's easy to do.
Wendy, I don't know if you wanted to say anything, otherwise we'll close.
I just wanted to add about your distinction. I think it's not clear to me. It is an interesting distinction, but it's not clear that the public law has the indemnification processes that you were talking about. So one could imagine that, but you know, we see it in workers' compensation, but in terms of most areas of health and safety, the public regulatory law does not provide for that type of compensatory system. If you want compensation, you have to go to tort.
Great. We're going to have to close it there. Thank you to the panelists.